Hi everyone, welcome from Law with Dunk, the Law Guy, and today I'm the Mighty Morphin Green Law Power Ranger, my favourite ever Ranger. And I'd like to do two recordings, with this recording being the first of today, and would therefore be the day 49 recording of the Case Today series journey to make up for what I wasn't able to do in the week, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Please do bear with me. With it being so hot, I might need a drink of water. Definitely not an alcoholic drink. Refreshing, that. H2O. Anyway, moving on. Anyway, today I'd like to continue to explore the meaning of the coincidence rule, which I refer to as a mens rea mechanism, by specifically exploring another way in which the coincidence rule can be achieved, which is by that of transaction theory. Transaction theory being where there isn't one continuing act, but instead numerous acts, or a series of acts/events where the courts treat the acts as one transaction, and where the defendant possesses a mens rea during one of these acts, it will be deemed as being present throughout the transaction. And just to stress, what I mean by the term mens rea mechanism, as I made it up to just hopefully help students comprehend this area of law, is because transfer of malice and the coincidence rule relate to an area of law and provide legal principles involving the movement or placement of the mens rea within the actus reus. This is why I refer to them as mens rea mechanisms and not mens rea tests, such as direct intent or indirect intent or subjective recklessness. Also, please be aware that I've already covered continuing act theory, which is the first form of coincidence rule, with the day 48 recording. So, why was there a coincidence of both the actus reus and mens rea in the case of R.V. Thabo Meli, 1954? In this case, 4 defendants wished to kill the victim, and so their intent to kill for the mens rea of murder could be seen to be present during the first act or event. This detail is very important. The 4 defendants decided to hit the victim over the head, and believing the victim to be dead, the defendants then pushed what they thought was the victim's dead body off a cliff. This was done to make it look like the victim's death was an accident. However, the victim wasn't dead from the head strike and was therefore merely unconscious when being thrown from the cliff. The defendant went on to die from the fall along with exposure to the elements, i.e. being left at the cliff bottom for too long. The defendants were convicted of murder at trial, but appealed on the grounds that there was no coincidence for the criminal liability equation to exist, that being an actus reus plus a mens rea equals criminal liability, or actus reus with causation if necessary, plus mens rea equals criminal liability. So, i.e., no coming together of the actus reus and mens rea here for the crime of murder. They argued that their mens rea of murder, i.e. an intent to kill when hitting the victim over the head, was formed prior to the actus reus occurring, i.e. the man went on to die later after the head strike. They went on to argue that when they threw the victim over the cliff, there was no mens rea for murder, as they couldn't intend to kill someone they believed to be already dead. The Privy Council upheld the defendants' convictions, deciding that the 3 events, i.e. the strike to the head, number 1, throwing the victim off the cliff, number 2, and the victim dying later at the bottom from exposure, number 3, formed one transaction, and as the defendants possessed the mens rea for murder during event 1, the mens rea was therefore present throughout the transaction, throughout the actus reus, or within the transaction. And that's it for this recording. I'll hopefully move to what should be the day 50 recording later today.